I'm going to be fairly quick because I want to learn from Larry. Larry and I are colleagues at Virginia. I've given the paper at a summer workshop, but Larry unfortunately wasn't there, and so it took both of us coming to San Diego for me to get his expert commentary. And I'm tempted to just put this as an appendix to the paper. It seems very helpful. The genesis of the paper, to the extent it matters, was this discussion in McCulloch about spirit and its role in interpretation. And in McCulloch itself, Marshall says things that, he ultimately upholds the bank's constitutionality, but in the course of doing so, he says it's relevant whether or not the statute is consistent with the spirit of the Constitution. So it's an interesting concession, one that if it wasn't made, no one would bat an eye. And I didn't know what it meant and kind of glossed over it when I taught it in class, but it kind of gnawed away at me. And I decided to look into it, and of course, Randy and others had looked at spirit as well, and that was a spur. And I had conversations with Mike Rappaport about spirit as well. As you know, what I found at least was of interest to me, and in some cases surprising to me, the extent to which spirit was used not only to choose amongst ambiguous definitions of a word or phrase, but also in some instances to overcome the letter described as such, either to expand the meaning or contract, and in some cases to do both. And so the paper just tries to describe this practice, how they justified it to the extent that they did, why they would be worried about it from time to time, and tries to participate in a conversation with several folks who have discussed similar topics earlier. So I'll leave it at that because I think I'll learn more from Larry, and I'm sure you will too.
This is really an extraordinary paper. And I think it's just going to be very, very important to the way we think about interpretation in sort of the 18th and 19th centuries. I think this is part of a larger movement. So there are others in the room who have been working on recovering the concept of the general law. And it's a similar development, I think, going back to organizing frameworks from earlier in our history. So I just viewed my job as trying to bring as much conceptual clarity as I could to this topic. And I think that that's very important because one of the things I think we all learned from Sai's paper is that talk about spirit was not perfectly clear and analytically precise. So I think one enterprise then, an important enterprise, is to try to translate this talk into the best conceptual apparatus that we can provide to figure out what was really going on. So the handout starts with this idea that we might approach letter and spirit literally, but that I think would be silly. Letter does not mean letters, and spirit does not mean some non-material entity such as a soul. These are metaphors, and the question is, what are they metaphors for? What ideas are represented here? So I detected at least 5 different approaches to letter and the spirit in the cases that Sai talks about. And then I've added a 6th approach, which is sort of all of the above mixed together. So let me just go through that, because I think that's the biggest contribution I can make. So this was very interesting. The first way of thinking about this is that letter is nominalism. It's just the name we give to something, whereas the spirit is actually the concept being represented. Now, you might think that has nothing to do with the letter versus spirit distinction, but Sai actually produces examples of this, the clearest of which is the treason treachery example in the paper, right? The idea that it would be ignoring the spirit of the law to simply look at the words being used. So if Congress enacted a treachery statute, that wouldn't get us around the spirit of the provisions of the Constitution that limit the crime of treason. Second possibility, that spirit is juxtaposed to letter in the same way that literalism or literal meaning is opposed to contextualism. So, and I thought there were multiple examples of this that Sai elucidated. So literalism is the idea that the meaning of a legal provision is its bare semantic content or its acontextual content, and contextualism is the idea that the full communicative content is a function of the meaning communicated by the words and other stuff like punctuation in context. And, you know, we have questions about exactly what the relevant context is. At the minimum, it would be the context of the entire text of a statute or constitutional provision. But a wider idea of context would encompass things that are revealed by the history of enactment or the history of framing and ratification of a constitutional provision. So literal meaning is very thin, it's sparse, it's incomplete, right? And it can lead to very paradoxical results. Contextual meaning adds both disambiguation, where context forces us to focus on the sense of a term that was actually communicated, and it also includes what in the philosophy of language and theoretical linguistics is called pragmatic enrichment, right? The things that are communicated but not directly stated by a text, or presupposed, as the Ninth Amendment presupposes the existence of unenumerated rights, but it doesn't directly say that there are unenumerated rights. So now, the third and fourth senses of the distinction between letter and content are very familiar, and they're highlighted by debates in statutory interpretation. So textualism might be the letter, but now I'm understanding textualism as the full communicative content, that is, the contextually disambiguated and pragmatically enriched communicative content, what the text actually says, versus intentionalism, the will of the lawmaker. So that could be the will of Congress in the case of a statute, or the will of which body the ratifiers say, or maybe the framers in the case of the Constitution, and amendments, of course, are different. And a variation on that would say that contextualized meaning of the text is the letter, but the spirit is the objective purpose of the provision. And of course, objective purpose and subjective intentions are two different things. Sometimes they come together, but sometimes they come apart. Sometimes they come apart in radical ways. And so these are really two different senses of spirit. And I didn't do a chart with all of Sai's examples. I'm just not that diligent. But I suspect that these two senses of spirit are the most common. This is sort of what is going on most frequently in the discussions. A fifth possibility is suggested by the work of Randy Barnett and Evan Bernick, discussed by Sai in his paper, that would use the lens of the interpretation-construction distinction. The interpretation part would be the letter, and construction within construction zones, as Barnett and Bernick see it, would be the spirit. And so that's a fifth sense. And now, interestingly, I just thought this was fascinating. In the paper, Sai sort of recreates Bobettian multiple modalities, interpretive pluralism, saying that different modes were being used. So spirit's used, and letter is used, and effects are used, and something like the British concept of mischief is used. A bunch of different modalities are being used. He sort of has recreated a living constitutionalist approach as the historical approach if we have this sort of multiple modalities version of the spirit. I'm only got a minute left, and I'm an originalist, so I believe 10 minutes means 10 minutes. What should originalists think about this? And I want to just say for now, I think that's theory dependent. It depends on what kind of originalism we're talking about. Original intentions, well, of course, then, subjective intentions go to the top of the list. If you are an original methods originalist, and perhaps an original law originalist, if all of these uses of spirit are part of the original methods, then I think you're stuck with them, Michael. But of course, there could be a big debate about exactly what the original methods were and what roles these played. Public meaning originalism, I think, will not necessarily be committed to the use of spirit in those cases where spirit would be used to override, modify, or change the original meaning of the constitutional text. I'll stop.
Any response?
Yeah, I'm just going to quickly just say a couple of things. I want to say, yeah, Michael, you're stuck. I don't know which Michael it is, but you're all stuck, according to Larry. And thank you for this, Larry. This you say you're not diligent, but this has equal substance as my paper, so I'm grateful for it. And then Larry said talk about spirit is not perfectly clear, by which he means there's all these different senses in which it's being used, and I clearly haven't broken it down in the way that Larry suggested, and other people have suggested. One reader said it wasn't fully digested, by which I think they meant it caused them indigestion, and I suppose it might have done the same to Larry. I was less interested in how they were using it, and more interested in the results that were coming out, right? That is to say, this notion that they discuss openly about extending a statute beyond the letter and restricting it restricting the statute from the letter, and not as interested in how each time they were using spirit, what formula, what sense of spirit were they using. And I certainly didn't have 6 different senses in the way that Larry helpfully laid out here. And then the final thing I'd say is, I think, it's not my modalities. This is in Blackstone, right? And Blackstone is saying it, and other people are doing it. And Blackstone's modalities are repeated in America by people who obviously have learned about the law in part through Blackstone and don't feel self-conscious about borrowing from it and doing so expressly. And then my final comment, is this living constitutionalism? I don't think so, because I don't think they have a sense that the meaning of they have some sense perhaps that the meaning might have to change to reflect unforeseen circumstances, but I don't think it's the sort of full-throated living constitutionalism that's familiar to us today. But I'll leave it with that and welcome your questions.
First point, I think you're bracketing this original law versus original methods point and treating them sort of more generally as similar approaches. I think that this paper argues from a theoretical approach of original methods originalism. You say that the practices that existed at the time of the enactment of a law is the way we ought to interpret that. That's original methods originalism. So I think that's great. So when Larry said, Michael, you're stuck with it, this is the Michael. Which gets me really to the next question, which is sort of, I also have a typology of sorts, but I've got 7 categories. But basically, I guess the question is sort of, what do we make of all these spirit references? And I mean, I'm not going to go through the whole long thing, but I think in the main spirit, it's something like purpose or intent. And so you're going to use purpose or intent to resolve ambiguity. You'll use purpose or intent to figure out absurdity under absurdity rule. You'll use purpose or intent to avoid an overly literal reading of the law sometimes. So the draw blood in the streets example is that's just what a literal meaning of draw blood would get the doctor, but not the way we would normally use the term. The spirit of the law also could be kind of like, what's the underlying principle or purpose of a law? So you could say, well, the Constitution, here's a constitutional amendment we're considering. It's inconsistent with the spirit of the Constitution. You might say, well, what that means is it has a different operating principle. It would be an introduction of a new point. But that wouldn't be a binding provision. That would be just a way of characterizing the Constitution and its underlying principles. Another sort of similar way might be to say, you use the spirit to guide your discretion. We're not going to bring an enforcement action here because it's against the spirit of the law. Even though if they did bring an enforcement action, it would be binding, right? So it guides political discretion or discretion of sorts. So all of that, I think, is completely consistent with Orthodox originalism. So you get spirit, and I'm totally fine with that. It's probably inconsistent with some John Manning type textualism, but I think consistent with originalism. I guess I think the real question, and sort of the biggest question I really have for you is, to what extent do you think there are examples in the paper that go beyond that? Now, I think sometimes courts talked about using spirit or when there wasn't an absurdity. It would be more convenient to interpret it a certain way. And I think that would be inconsistent with a sort of Orthodox originalism, although still would be originalist as long as you didn't, look to purposes that weren't the framers. I think that existed, but I think it was a minority view. In which case, the end of the story is still where the spirit is consistent with, Orthodox originalism. But I wanted to know if you thought there were a significant number of examples that departed from that.
Sai, I just want to invite you to say more about why this practice of spirit is something that originalists should honor, because there is a sort of conventional view that originalists are about the original meaning of the text, and so this in some ways just picks up on part of Larry's challenge. And so what is it about the original meaning or understanding or practice of non-textual things that you think is binding on originalists? After all, the framers also, appeared in court dress and wrote in quill pens. And we don't necessarily think that all originalists have to continue to do their analysis in quill pens or seriatim opinions. And in particular, obviously I'd like to invite you to join the turf war between original methods originalism and original law originalism, both of which would have answers to this question. And I'd invite you to join our team, but either way. And if it's not in either of those, which seem like the most natural explanations, then what is it, and why should originalists do this original non-textualist thing?
Don't quote me.
Great paper. My question is really Will's question. Maybe I'll just expand on it a little bit. You know, the paper is overwhelmingly descriptive, right? It's sort of trying to say, look, spirit played this really important, or this series of really important roles at the time. And then, at the very end, it becomes normative. The last sentence of the abstract, one should not make sense of their legal instruments, including the Constitution, as if they were authored by the severe and scrupulous textualists of our era. So at the end, you're kind of saying, and there's a normative payout here. And I wanted to sort of ask Will's question, why? I think most originalists today don't tend to defend originalism on the ground that the framers were originalists. That's a circular argument that doesn't convince anyone who's not in the choir. And I think for most public meaning originalists, I think the answer that they might give to this paper might be something like, okay, maybe the framers didn't engage in public meaning originalism, but we still think it is the correct method of interpreting the Constitution, even if they didn't. And what's your answer to that? And I think in the paper in part 3, you say, well, spirit played an important role in the ratification debates, which might suggest that, those originalists who are defending originalism normatively on popular sovereignty grounds should understand that what was understood, the constitutional meaning was understood at the time to be spirit infused. But that not all originalists defend originalism on popular sovereignty grounds, and I think the historical facts aren't great in that regard. In part 7, you talk about, well, actually, Article 3, the original textual meaning of Article 3 might have spirit imbued in it, but then you go on to rightfully say, but that wouldn't affect state courts or non-judicial interpreters. So I guess I am sort of curious, the same question as Will, what's the takeaway for the public meaning originalists in this room? If they're sold on your descriptive account, what does that change, or why should that change what they think the proper method of constitutional interpretation should be?
Sorry.
Well, thank you for all those wonderful questions. I guess I'll try to lump Will and Thomas's question together. If someone, is an original meaning, whatever, an originalist and focuses on the original meaning of the text without regard to purpose or intent, and they're doing so because they just think that's a better system, not because it was a practice at the founding, I don't think this paper really speaks to them. It seems to me that that's just a theory that has nothing to do with what's going on at the founding. It's just, I assume, some sort of consequentialist reason for doing that. And I understand why you might, have other reasons for the methods one chooses that have nothing to do with the methods from the past. Related to Will's question about the original meaning of the text is the thing that unifies originalism. I guess that's one way of understanding it. Another way would be the original meaning, and not just the original meaning of the text, because one of the points of the paper is to say they understood that the text conveyed a meaning, but the meaning they drew from the law, more generally, wasn't just a function of the text. And so if one focuses on the original meaning of the text, obviously this paper discusses a bunch of things that are relevant because it's not talking or focused on the original meaning of the text. So, I think the paper doesn't purport to have a reason for why people that care about, I get what I'd call semantic meaning, or what you and Will call the original meaning of the text should care about this. I think it's kind of odd to call it the original public meaning if no one had that meaning, if no one subscribed to the meaning, right? So you can call it, you can call it that, or you can call it SOFA or whatever you want to, but it seems like it's mislabeled, right? Because if your reading of the text is not one that anyone had, and in fact, anyone who spoke to the matter rejected it, yet you insist on calling it the original public meaning, I just don't, I think you're mislabeling the theory in some sense. So there are reasons to be sort of more textualist and less concerned about intent or purpose or any of these other concepts that Larry helpfully spelled out for us. But it seems really odd to me to call that original public meaning when no one at the time would read it that way. That's not an argument against the theory, but it does suggest that there's some confusion in its labeling, if that's what you're going to call it. As for Mike, Mike said a lot of interesting things, and I'd like to speak to him separately about him. He wanted examples that didn't fit into the conventional framework for originalism, things that weren't absurd. And I think there are plenty of examples in the paper where people read statutes or constitutional provisions in a way that isn't absurd, and they use spirit to reach a result that, as you said, isn't absurd. The Blackstone example from the shipwreck, I don't think it's absurd to give someone money who's sick on a ship. I don't think it's a good use of money, but it's not absurd. The subsidy example of the salt subsidy, are we going to give a salt subsidy to people who are exporting things that have salt in them? And Hamilton says, no, we're not going to, even though the statute that repeals the subsidy is prospective, we're not going to give people the subsidy because it's inconsistent with his sense of the spirit of the statute to do so. I don't think it's, we give people money all the time in ways that are terrible, but not absurd. I think a lot of the examples aren't really that absurd. The claim that the federal statute that gives money to witnesses in federal court, the claim that it should be read to extend to witnesses in state courts, where the cases are hearing federal cases. I don't think it's absurd I don't think it's absurd to fund one and not the other, right? So, in many of these circumstances, one can conceive of a reason why you do one thing and not another, yet they're still making a spirit-based claim. So I actually think it's not just a question of absurdity or some such. I think they think they rightly or wrongly, I don't take a position on most of these things, they think there's a purpose, and they think they're furthering the purpose by creating an exception or by expanding the meaning of the statute. And I would say that most of them are not absurd, right? They're not creating the exception or expanding it to deal with some absurdity.
I could just say one thing. So the word meaning is really ambiguous. So when Sai makes this point that that someone who focuses on, let me use a more precise term, the original communicative content of the text, is not getting at the real original meaning. He's using meaning in a particular sense. He's using meaning to refer, I don't know exactly because he didn't specify, but something like the original legal content. It might be the original law, or maybe he is referring to the original results that would have been reached given the original methods of constitutional interpretation. We can call all of these things meaning. There are different senses of meaning. So it is real to say that the original communicative content was a thing then. And if it hadn't been a thing then, there wouldn't be a letter and spirit distinction, right? The letter and spirit distinction assumes that there is communicative content that might be different than the subjective will of the lawmaker or the objective function or purpose of the text, of the statute, or of the constitutional provision. So I think it's always important to ask what you mean by meaning in conversations like this.
Okay, next we have.
See, this is on. This is a terrific paper, Sai, and it's something that I've long thought. My first article was about the case of the prisoners, which is the first Virginia judicial review case where they're using spirit all the time, and you cite that. But I think I'm not sure that that's right anymore. So I wanted to focus one question. Larry has nicely framed, different approaches. So one question I'd have is, I think you've established that use of spirit is a modality. And the question is really, for me, is it the dominant modality? So it seems to me that there's almost a northern-southern split. So the Virginia judges, in kind of a hierarchical society, where the judges are lawyers and planters and are clearly at the apex, the judges get deference, and in constitutional law, their acceptance of spirit is something that makes sense to people and they don't push back. In the North, which is not as hierarchical and where lawyers are not as powerful, I don't think you see the same kind of use of spirit, and judicial review is also much more controversial. So, just a couple of examples. One that struck me is, you say Hamilton in 45 can't attack Brutus because in 44, Madison invoked spirit. Well, Madison invoked spirit. Madison's never really a textualist until kind of late in the game. So, just to give you a concrete example, in the Helvidius Pacificus debate, so Hamilton does kind of a Scalia-esque hypertextualism to get to unitary executive. Look at the vesting clause and look at the difference between Article 1 and Article 2 vesting clauses. It's Scalia-esque. And then Madison's response is, he says, that's inconsistent with the spirit of the Constitution. So, I guess, and again, I was struck as you went through the judges on Constitution, not statutory interpretation, but on Constitution, they're almost all Southern judges, whether it's Roane, and some of them are Federalists, Marshall, Madison, Tucker. So the question is really, I think you've established very powerfully that this is a modality, and the question is, for me, is it a dominant modality?
Elon.
Sorry. So my question is a version of Mike's question. So I'm just going to ask it again, but maybe in a slightly different way. Could you just summarize what work you think Spirit is doing that isn't already being done by more specific and arguably precise legal concepts that are already used as tools of interpretation? Like for not just absurdity, mischief rule is one example. Another is the expressio unius canon. I was actually struck by certain examples in your paper. Why can't Congress alter the Constitution? Well, because Article 5, is an example. Is that spirit? That's just expressio unius. That's how language works. And so my question is, when we eliminate all of those other concepts that already exist, what's left of spirit, and what work does it do that those other concepts don't already do?
John.
So thanks for this paper, Sai. It was very interesting. I wanted to ask you whether at the end of writing this paper, after writing this paper, you think any differently about two specific parts of the Constitution, and whether you now have maybe a different view about how the founders thought about these two parts of the Constitution. One would be the preamble. The famous "let the end be legitimate" passage in McCulloch is one in which Marshall is arguably referring to the preamble because he refers to the ends within the scope of the Constitution. There's at least one reading of that passage in which he's referring to the ends of the preamble, and there's no question that the preamble was invoked often in these contexts in which spirit was discussed at the founding. And the other is the grant of jurisdiction in Article 3, Section 2 to the courts to all cases in law and equity arising under the Constitution. You talk about Brutus and you talk about a grant of equitable jurisdiction, but the particular formulation in Article 3 I think is really striking, and I think this is what Brutus was noticing, because it implies that there's a category of cases which are describable as cases in equity arising under the Constitution. And the question would be, how do you now think of that statement and its implications any differently after writing this paper? And how do you think maybe differently about how the founders might have thought about that issue now that you've done all this work on spirit and discovered just how prevalent appeals to spirit were and the kinds of work that they were doing?
Awesome. So, Bill, is it the dominant modality? I don't think so. I think text is still the dominant modality. I just think that they don't stop there. They talk about a plain spirit or an apparent spirit overcoming the plain meaning of a text, and so the spirit can be quite powerful, but most of the time people read a text and come to a conclusion about its meaning fairly quickly, and they're not necessarily thinking about the spirit. I think it's only when they need to, because the text might be against them, or when they have more time, that they can wrestle with that. So I don't think it's the dominant modality, but it's clearly a powerful one because they're using it to create exceptions and to expand the meaning of the statute beyond the meaning suggested by the letter. I hadn't thought of the north-south divide at all, so I haven't sort of thought through where these people are from. Hamilton is from the north, and he's using spirit. I don't actually think there is a north-south divide, but I haven't gone through everybody to sort of characterize them. But Hamilton says, right, every lawyer knows that we use the reason and spirit to figure out what the statute means, right, what the Constitution means. And he's making all kinds of spirit-based arguments before the Constitution. And he's making them afterwards as well, right, about the statutes, et cetera. So I don't really know whether there's a north-south divide. I'd be surprised if there was one. They're all reading Blackstone, right? And there are people in the north like Swift, who was saying that we ought to be construing constitutions and statutes. So I don't know about the north-south split, but I'd like to think about it some more and hear more from you. Elon had the same question as Mike. I mean, you can decide for yourself. I mean, it's a game, right, to say, well, they got the right result, but they used the wrong reasoning. I don't think they're using the mischief rule or the expressio unius to get a lot of these results. The statute says the subsidy no longer exists, and Hamilton says we're going to apply it retroactively, even though the text doesn't say that. I think expressio unius would imply that you're not supposed to apply it retroactively, but he does anyway. I think there are lots of examples of this. And of course, there's what they're doing and whether we can have a better justification for it. But what they're doing, I don't believe, is what you're describing. But perhaps I've misdescribed what's going on. And then John's question about the preamble, I included it because it was, that's what Story did and said. I think the preamble has to be relevant to understanding the Constitution. I don't know if I've changed my mind on that. I don't really know if I had thought about it enough before, but it seems relevant to me now. The arising under stuff, I'm not sure what you meant by that. I haven't given a lot of thought to that theory beforehand. But one of the conclusions of the paper is that spirit is not the particular province of the courts. And so every legal instrument, including things like judicial orders and precedents, are being construed, including executive rules, are being construed using spirit. So if that's true, obviously it applies to the Constitution. And of course, the paper is chock full of examples of people saying the text suggests A, but the meaning is less than A or more than A. So if that's what you meant, yes, I've changed my mind because I did not know that this was a practice or that this was happening as much as it seems to have been.
If I could comment quickly on a relationship between Bill's comment and John's comment. So, Bill, I think that this idea of hierarchical societies, and I would put this in terms of trust in authority, is very important in the context of spirit, and it becomes more important the higher the level of generality at which the spirit is expressed. So in the case of the Constitution, if the preamble gives us the spirit of the Constitution and every other provision in the Constitution can be modified if that's required to realize this general spirit, that of course requires enormous trust in judges because they're, that spirit can have diametrically opposed implications for some issue in constitutional interpretation and construction, depending on your views of what the general welfare is and what the blessings of liberty are and so on. To me, this is very important to the normative significance of spirit today. I think that the Barnett-Burnick style spirit, which operates at sort of the functional design of particular clauses and perhaps the interaction between particular clauses, that requires much less trust than authorization of the Supreme Court sort of to modify constitutional text, modify the letter in light of the general spirit of the document as a whole.
Okay, next troika, Lawrence Klaus, me, and Judd Campbell.
There we are. Now you can hear me. So when we go to Marshall's opinion on which triggered this reflection by you on spirit, isn't there a sense in which the way Marshall uses spirit alongside text, in that case, in Fletcher and Peck, in a bunch of his decisions, perhaps reflects an ambivalence between the Chase and Iredell approaches from Calder and Bull to the whole constitutional project, right, of adjudication under this written constitution, right? Chase is saying this is an illustrative document. You know, we're taking basically a common law approach that we've always had when deciding cases in the past to this new document where we just ask, okay, what bigger principles does this text reflect? What bigger principles does a judicial opinion reflect? And those words just become jumping off points to an exploration of principle that can be applied in ways well beyond what the triggering text says. Iredell, on the other hand, saying, no, this is a definitive document. You're confined to its four corners. That's the whole point of writing a constitution, right? Marshall seems ambivalent between the two. He always talks about text, but he always wants to talk about spirit too. And when you look at the way he actually uses it in McCulloch, right? He's got some text to work with for federal immunity, right? He's got the supremacy clause. He chooses not to stick to that. He chooses to talk about the nature of sovereignty, a bigger principle of sovereignty, in a way that lets us later create a totally non-textual state immunity from federal law, right? So he's choosing to do this thing, which is the same kind of mental gymnastics with text that invents some substantive due process, right? It ends up being this way that we take the text not as defining the boundaries of a concept, but rather as merely an example of a bigger principle of liberty, which we can then use in new ways, or a bigger principle of state sovereignty that we can use in other ways that we judges discover as if we were common law judges merely reading the words of judicial opinions. In that sense, the spirit concept just becomes a way to do everything that living constitutionalism would want, right?
At one point, Sai says, well, I don't know what 2 Corinthians means. And I thought, well, I might give that a shot. So broadly speaking, it seems I would love this to be more about just the nature of language in general. So you need more Aristotle. I don't think you have any Aristotle, but more Aristotle, more Jesus, and more David Kaplan. So the Aristotle bit, I mean, if you go back to like Easton versus Studd from 1574, the argument in 1574 that Plowden is making is based on Aristotle. So Aristotle has this example of hitting somebody with an iron. So you got some statute or something saying, don't hit people with an iron. Well, somebody's wearing an iron ring. And there is, well, come on, that means the come on response. In terms of interpreting 2 Corinthians, I think if you look at Colossians 2, it's very, very compressed, all these phrases in the one letter about, the Spirit killeth, the letter killeth, but the Spirit giveth life. If you look at Colossians 2 and the end of Mark 2, especially the bit where Jesus is talking about the Sabbath, and so he's getting hassled. His people are getting hassled. Well, why are you having why are your disciples picking grain on the Sabbath? And his response is, oh, come on. If your donkey fell into a ditch, you'd take him out on the Sabbath. Even David, when he was running away from King Saul, went into the temple and ate the special bread. So Jesus is basically saying, well, there's a military necessity exception to these things. And it's actually pretty similar to the kind of stuff Aristotle's saying, and the kind of stuff that people like David Lewis say. You open the fridge and you say, there's no beer. Like, no beer anywhere? Well, no beer in the fridge that you just opened. Okay, you have a come on kind of defense. And David Kaplan's stuff on character versus context sensitivity of language. I think this should be about more than just the 18th and 19th century. This should be about language, because that's how Blackstone thinks of it. Blackstone is not saying I have this special thing that we're doing in the common law. He's saying this is just how language works, and I think he's right about that. So anyway, Judd.
I think the paper works well as a descriptive account of how the founders are talking about interpretation. One thing, were you interested in doing something broader, and particularly with a jurisprudential upshot today, that I would be interested in seeing is what are the predicate assumptions that people are using to develop a theory of spirit? And along those lines, I would suggest here, building directly on Lawrence's and Chris's points, that people at this time are natural lawyers. They have not the view of natural law applies as such that somebody like H.L.A. Hart is pushing back against, but the view that law exists for a purpose and that there is, in like some sense, a kind of divine provenance to humanity and to the way in which we organize, and that tells you certain things about the nature of law and the nature of political authority. And therefore, for somebody like Marshall, let's say, you can hide the document and he can nonetheless tell you certain things about that document, knowing just what type of document it is. So in the nature of things, he says, there are certain attributes of sovereignty. In the nature of things, there are certain aspects of what it means to have implied powers. And then, of course, he links that to particular aspects of the document. But I wonder if that way of thinking about spirit, at least to some extent, that way of thinking about spirit is predicated on these sort of broader jurisprudential assumptions that people bring to the table as natural lawyers. And then from the standpoint of a kind of modern effort to use this today, you would need to grapple with, well, what do we think about the idea that there is a purpose or a cause behind the law if we're just public choice theorists who think that all of this is just an effort for power grabbing, and therefore the best we can do is just to focus on the particular political bargain that was reached, which is these words, and that's all we've got to go on. There is no general will. There is no common good that we can conceptualize separate and apart from what subjectively individuals have fought over in the arena of politics. So it seems like if you're trying to make use of, not to say we can't conceptualize what they've done in our terms, see Larry's chart, but if we really want to make use of their way of thinking about spirit, what do we do with the abandonment of the sort of jurisprudential foundation on which it perhaps laid?
Sorry.
Well, great. Let me discuss Judd's thing first, since it's top of mind. I don't think most of the examples are natural law examples. And so to think that this is just a product of natural law to me is a mistake. So, I don't think it matters to natural law whether two commandants get extra rations. Right? I don't think there's I just don't think that that's, or a subsidy, or many of the things that we're talking about, they're rather ordinary things, and they're still using spirit to achieve a result. So I think some of the things are natural law, right? The claim that you shouldn't execute someone unless you need to sounds like it's more natural law-y to me than most of the examples. And I can see how someone who doesn't believe in natural law could believe in this theory, or believe that this is a good practice. So I don't think it's just natural law, but I have heard others suggest that I ought to look more to that.
And can I interrupt just a second?
Of course, please.
So the point is not just that the content that they're drawing from is from natural law, but that the habits of mind, the way in which they think about what the law is and what the point of law is and how the law should be interpreted are shaped by their acculturation as natural lawyers. So it's a slightly different point than what you made.
Well, maybe you're right. I mean, I don't, I need to think about it some more. I do think they agree with the point that law exists for a purpose, but I don't know who wouldn't. I mean, maybe I'm mistaken. I do agree with you that they aren't as sophisticated as the lawyers of today in coming up with a reason why they came up with this language and why we can't extend it further or narrow it further, right? So the example of, salary protections for judges, I can tell a story for why they were only able to get this language through. And so you can incentivize them. You can give them, you could pay them $10 as their salary and then give them, $100,000 if they uphold every single statute. And to the claim that that's not the purpose, I'd say, well, look, maybe they wanted to do more, but they just couldn't get it through the committee, right? So maybe they're not as good as figuring out clever arguments for why there is no purpose. This is just a messy compromise. I'm not sure that reflects our practices today or our conception of what law is today. I think it's a clever and I think interesting point to say that we can always come up for some reason why they came up with this text and why therefore we can't depart from it in any particular way. But I don't think that most people have that conception, notwithstanding the insights of public choice theorists. Chris's comments are interesting. 2 Corinthians, I've said enough. I did a little research on it, and I could not make sense of it. People, as you might suspect, who are Christians have various readings of it, and it doesn't really matter to me what it means, to be honest with you. I don't have a stake in that game. I'm happy with whatever other people take it to mean, but it's interesting that so many Christians have told me this is what it means, and you should put this in the paper, as if it's going to matter to anybody who reads it. It's not about 2 Corinthians, right? It's just about the idea that this juxtaposition, this thesis antithesis, may go back quite a ways, at least in Western thought. And then I think, more generally, I think this is the paper Chris would have written and not me, which is great, and I encourage Chris to write it. I think, Lori, to your point, they understood and they said this, right? The people that, most of the times people are using spirit, they're not justifying it, they're not defining it, right? That's why it's, all over the place. But the few people who spend time thinking about it more generally basically believe that the text is an imperfect expression of the will of either a single person's will, if it's a single person authoring it, or multiple people, and that we should try to access the will not only by looking at the text. That's, I think, the theory of what they're doing. And so from that point of view, it makes perfect sense to them to look behind the text to this will to make sense of it, not only to deal with ambiguous expressions, but also to understand that some text doesn't fully capture what they're trying to accomplish, either because it's too broad or too narrow. Is this what living constitutionalists would want? I think you say this at the end. Obviously, the more factors you have, the easier it is to do that which you wish to do in the present. And there's a sense in which introducing spirit or will or purpose or what have you, intent, makes that possible. I don't think that the founders were living constitutionalists. I think when they do talk about methods, they talk about the original meaning of the words. Vattel says this himself. I think Blackstone does as well. And then they talk about the actual purposes, not the purposes of the person who's trying to interpret the document. But they know full well that when you introduce spirit, people are going to read it from their own perspective of what they want to accomplish. So they're not naive about it. They say this openly, right? That if you have too much spirit, you're going to destroy law. But their solution is not to banish spirit. They keep it within the fold and try to, as best they can, not allow their own sense of spirit to dominate the meaning of the text or meaning of the law more generally. That's the better way of putting it. So they understand the weaknesses of the project, and they understand it's dangerous, but very few of them say we should just get rid of it.
Okay, we have 10 more people and 15 minutes, so if we double time it or something, we can get through these. Next group, David Upham, Tommy Berry, and Adam Griffin.
Thank you very much. I thought it was a very important paper, a great contribution, and it's just useful to understand how widespread the use of spirit is. This is outside the scope of your paper. You need to write another paper. But it would be perhaps even useful, perhaps an introduction or a conclusion to talk about the prior or subsequent uses of spirit. I just did a quick nexus search here on spirit of the law in Supreme Court decisions, and there's almost nothing in the 20th century, even in oral argument. And that would be relevant, especially if someone said, well, spirit of the law is very useful to living constitutionalism. If during even living constitutionalism in its heyday, its proponents were reluctant to use a very familiar concept, it'd be just interesting to know why that was. Second, this is related to your paper, the taxonomy of both Blackstone and Story. In reading it, I was frustrated in a sense. I know there's something more here, and I'm very much grateful for Larry for providing a taxonomy. It might be good to map that also onto the categories of Blackstone, because it's pretty obvious that some of the spirit isn't what he calls spirit. He uses it for some of the other categories of modality. And let me just rehabilitate Chris's remark. It matters a lot if there is a very prevailing understanding of letter and spirit that has a kind of gravitational pull on the way, I would say partly a kind of authoritative but in fact loose use of spirit. Because it but the second is, it may be that it works more for honoring the lawmaker or the Bible maker. And so there's going to be more uses of spirit where it comes down to, well, what was the motive of the lawmaker? Also, just maybe some Montesquieu. Does that book, which is so influential in the United States, have something to do with the use of spirit? Does it increase its use? Does it moderate its use?
Tommy.
On criminal law, you write about situations where the letter of the law might criminalize conduct A, B, and C, but the spirit only criminalizes A and B, and how a judge might use the spirit to say we shouldn't criminalize C. You say James Wilson argued you shouldn't go in the opposite direction. You should never say the letter only punishes A and B, but the spirit covers C, that doing that would sort of go against the rule of lenity. I'm wondering, did you come across any examples where judges maybe did do that, use spirit to expand criminal laws, or did they seem to consistently agree with Wilson that that would be unfair? And if they, part of why I ask is that one of Justice Scalia's arguments for why textualism is fairer, he said anything else would be like putting a rule up on a signpost too high for anyone to read it. And I wonder if you think maybe that's a good argument for textualism in that particular context of not expanding criminal law, using spirit to expand it beyond text, but maybe it's not as relevant in other contexts.
Got it.
Oh, this one has no LED, sorry. So it's a great paper. It's really interesting to look at the spirit as a part and parcel of the interpretive rules. But you sort of set it up as in tension with Justice Scalia and Garner's methods of interpretation. And I'm wondering if there's a way to sort of view spirit as sort of part of the best reading of the law, sort of the best or fairest reading of the law, rather than as sort of superseding or expanding the text. I think that Scalia said, he's not a loose constructionist, not a strict constructionist, but is going for the fairest reading of the law. And so if you look at sort of historical context, or you look at the mischief rule, or you just look at the context in which the law was drafted, if that actually is essential content to the text, if the spirit that they're talking about is actually essential context to the best reading of the text as law. And so when they say, well, the spirit's overriding the text or something like that, they're really more talking about we're getting to the best legal understanding of the provision that we're interpreting rather than, what might look like a literal interpretation of the text.
Mm-hmm. Well, great. Let me talk about Adam's comment first. I wanted to have a foil, and Justice Scalia said that the spirit should not be read to overcome the law. And in fact, people said that all the time, and unfortunately, he never quotes any of them. Nor does he quote anyone saying what his point of view is, right? He neither quotes the people saying that which he disagrees with or finds anyone who agrees with what he says. So you're right, he also talks about a fair construction. And of course, you can use spirit to come up with a fair construction, but you can't have both the view, I think if you're Scalia, of I believe in a fair construction and I don't agree with spirit, at least if your claim is the founders had my view of reading statutes and constitutions, right? Because he's saying at the one time, I believe in a fair construction and we should never use the spirit to overcome the letter, when they're in fact doing both. And you're right that you could say, well, they're not really overcoming the letter because they're following a fair interpretation of the statute. I think that's just splitting hairs, or it's just trying to avoid the conflict that I think is part of Scalia's discussion. Tommy's, is it Thomas? I'm sorry, Thomas. Tommy, the vice and the virtue of the paper is it's just focused on spirit. So I didn't go and read a bunch of criminal cases to see if they're following the rule of lenity or not. And the other vice of the paper is there are other times where they're using spirit, but they're just not using the word. I just thought it was interesting that Wilson says you should use spirit to narrow the ambit of the statute if you believe the statute wasn't supposed to go as far as the letter suggested. I have no, I don't know enough about, I know that there is this rule of lenity, and I think it existed back then, but I don't know enough about how it was applied to to give a good answer to your question. David's question, about Montesquieu, I looked up Montesquieu and I forgot what I found, and so it's not really in the paper. I have to go look it up again. I'm all for rehabilitating whatever Chris said about 2 Corinthians. I guess, to me, my buddy Caleb Nelson told me that there was this thing in the Bible that I didn't know about, and I thought it was useful to put in. Others have had the same kind of view that you had, that maybe there should be more discussion of spirit in biblical interpretation, and it's just going to be hard for me to do. And having done a little bit of it, trying to figure out what this meant, I just found a bunch of people coming to different conclusions, and I don't really feel like in most of the paper, I'm not really interested in whether the reading is right. The point is just to point out that people are reaching conclusions that don't seem to cohere with the semantic reading of the text. And then prior and subsequent uses. Oh, yes, this is super interesting. So my friend Justin Driver actually had his research assistants look at spirit in the Supreme Court. And he finds lots of it in the obviously late 18th and all the 19th century. And then I think he finds very little of it in the last part of the 20th century. And it's kind of what you would expect. Now, again, the problem with that is, are they just using some other word that does the same work? In which case, it's not really showing as much. But he has done that which you're discussing. I don't know what he's going to do with it.
Okay, next, Lorianne Updike-Toller, Sharif Gurgis, and Andrew Deloach.
I have been waiting for you to write this paper for a while, Sai. And generally, I think that Blackstone's theory of interpretation is under-theorized. And I wonder if an alternative title would be, let's make intentionalism cool again. And is it all that bad? But I do wonder how, you didn't talk about Bork at all, but if he's the godfather of originalism, I think he would have something to say about this in terms of looking at things from its purpose, which I still think has purchase, at least with some theories, some of them not originalism. So how does it interact with those strains? And I have often wondered why we have banished intentionalism like a redheaded stepchild for so long, when it's difficult in practice to separate the parts of our brain that intend something or give it a spirit versus what we mean. Like, how do you separate those cognitively? And is I see this as an effort to reunify parts of the family that have been separated by age. So I wanted you to respond.
Sharif.
Thanks. I enjoyed the paper. I was wondering, like Lawrence, what of originalism or textualism survives it. And so if spirit can be used not just to fill gaps and resolve ambiguities, but to shrink the text, to expand it, to supply norms that don't have a footing in the text, to supply values that the interpreter can repair to deal with new circumstances, what's off limits? And in particular, can you think of a kind of move that Ronald Dworkin or David Strauss would want to make that the spiritual textualists would not be allowed to make? And some of your answers to Lawrence maybe suggested a possible unifying constraint, which is that for you or for the textualist who adopts these dominant forms of reliance on spirit, the use of spirit is justified only if and only if, it gets you closer to the application of the norm that the author would intend if they were on the spot. Is that right, or is that missing something? Because that would be something that I take it Dworkin and Strauss would want to go beyond.
Andrew.
My question is pretty close to Judd's, so I won't belabor it, but I was curious to what extent, given how frequently we have this language of strict adherence to spirit, to what extent is recourse to the natural law, permitted? Feel free to punt on that since you already answered Judd's question. I'll just add that St. Augustine wrote a tract called The Letter in the Spirit, which would probably explain what you want to know.
Well, Andrew's question again, I'll take that first. The paper isn't suggesting that you shouldn't use natural law to make sense of the law. It's just not really discussing it at great length, right? So the fact that it's not discussing context or subject matter or any of the other things that Blackstone is talking about at great length doesn't mean to suggest that I think they're wrong in some measure. Perhaps it's interesting that there's sort of natural law isn't one of the 6 factors that Blackstone cites, right? It's 5, and natural law isn't one of them. I'm not saying he doesn't discuss it elsewhere. I just don't know. There's nothing in the paper that commits me to saying that natural law didn't matter to them. I'm not sure I think that's true. But it's just not something that the paper is discussing and won't discuss because it's just, it's too long as it is. And then I think Sharif's absolutely right that the goal is to think about their purposes, what they're trying to accomplish, not what you would accomplish if you had authored these words and gone through the process of making law. So that is a constraint. It's not obvious it's going to be a strong constraint because, again, people of the era understand that once you start using spirit, there will be as many spirits as there are people, and maybe more spirits than there are people, right? They say this repeatedly, right? I mean, Blackstone endorses spirit, but says if all that we have is spirit, we have no law. And if we have to choose between all law and all spirit and all text, we're better off with all text. But he doesn't believe that we have to make that choice. But I don't think that they believe that every person interpreting a statute should just understand the words as if they had written them with the purposes they had in mind. But they also understand that that's not obviously a super strong constraint because people will nonetheless naturally do that, right? It's hard to escape what's going on in your own head as you read these things. And then Lorianne's helpful questions and comments. There is no discussion of Bork. I use Scalia because he expressly says this. I don't remember what Bork says about spirit or intention. That's a helpful suggestion to see what he would say or what he has said. Let's make intentionalism cool again. I don't know if it's cool. I guess it's useful to know their practices independent of whether you think they're good practices. Again, I do think that to talk about the original meaning of a provision in a way that doesn't reflect how anybody at the time took it to mean, I'm not sure that that's an accurate description of what original meaning would be. And when people talk about, asking what a person at the time would take it to mean, but then say, but you can't consider the spirit, well then, in what sense is that person really doing anything relevant to what people at the time would have done? I don't know why the construct sort of seems odd to me at that point, but maybe I've missed something about the utility of the construct.
So, thank you.
Thank you, buddy.